Good morning, and welcome to the ABA section of Environment, Energy, and Resources podcast. My name is Nikki Ann Clark. I am a retired judge. I retired 2 years ago from the Florida District Court of Appeal, which covers Tallahassee to Pensacola. And prior to that, I was a Second Circuit judge here conducting trials, and I did that for about 16 years. Our guest today is Maribel Nicholson-Choice. Maribel Nicholson-Choice is a shareholder with the Greenberg Traurig law firm. Her primary concentrations are in the area of hazardous waste regulation, air and water quality regulation, environmental justice law, brownfields redevelopment, and environmental legislation. Maribel served from 1994 to 1996 on the Florida Environmental Equity and Justice Study Commission. And Maribel, thanks again for joining us. I'm going to be asking you questions about what your practice is and about generally what environmental justice is. So in fact, let me just start with, what is environmental justice? Is it a concept? Is it a set of laws? Is it an aspirational goal? What is it?
That's a really good question, Nikki, and I appreciate your time, and I'm happy to be here. Environmental justice is a very interesting issue. It's raised by regulators, environmental groups, and universities, and it's a term that encompasses a combination of issues. It can be used to critique technical and policy decisions being made regarding siting decisions, cleanup decisions made by regulators. The EPA actually defines the term, though, and I think that's a good place to start.
What's the definition?
The definition by EPA is that environmental justice is the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, or income, with respect to the development, implementation, enforcement of environmental laws, regulations, and policies. In Florida, it has been raised in several contexts, but primarily it's the idea that any type of environmental law that's on the books should be equally enforced, irrespective of the community that's affected. In essence, that's, I think, what environmental justice is.
Okay, is there what groups are intended to be protected by these laws and ideals?
The affected community, and the focus is to protect low-income and minority communities.
Now, Maribel, you've worked on environmental law pretty much your whole career, more than 20 years. Who is involved with the environmental justice issues that you handle? I mean, are these issues raised by citizens groups, environmental protection advocacy groups, governmental agency? Who raises these issues and in what form?
Well, in the concept of my practice, environmental justice issues are normally raised by affected communities in a development project. Primarily, my practice focuses on cleanup and redevelopment of properties, and oftentimes my clients are selecting properties based on location, just a traditional real estate standard. Well, a lot of the times those projects tend to be in urban areas. For example, an abandoned underground storage tank, gas station could be a potential site. Well, you'll often find those in urban areas, and so the community around those properties tend to be low income, poor neighborhoods. So in that context, when a client is looking to clean up the property and redevelop it, you would think ideally that would be great news. However, a lot of times the communities that's affected by that development are concerned about the type of cleanup and the type of redevelopment, and whether the cleanup standards at the property are going to be abbreviated or not. And that's where environmental justice issues come up. It comes up in Florida in local siting decisions and in cleanup decisions being made.
But who gets to raise these issues? I mean, are ordinary citizens empowered to take action to enforce environmental justice standards?
Well, that's a really good question. In the context that is raised in local decisions, you would see it when a permit is being issued, for example, and a hearing is being held to approve it. There's always a public input portion of local approvals, and it's that point of entry where you'll hear from the affected community. The local government tends to become a bridge between the community and the developer, and especially in advanced local environmental programs like we find in South Florida, Broward County, Miami, they actually set up citizen advisory boards that review projects, cleanup projects. And these citizen advisory boards usually have people involved that are from the areas where there's a concentration of development. So you'll hear within the context of the citizen advisory board issues raised related to environmental justice, and you could also hear it in a public hearing, in the public hearing portion of any project where people are allowed up to 4 minutes to raise whatever concerns they have. They raise issues in that context about environmental justice. They want to know what's going to be built on their property. They want to know what type of constituents are being cleaned up, or what kind of constituents are uncontrolled at the time. They want to know how that affects their water supply. They want to know how that the air they're breathing. I think now, more than 10 years ago, we have a much more sophisticated citizenry where you can get online and you could punch in your address, for example, on the EPA website, and you can find out what facilities are in your neighborhood, what regulated facilities are in your neighborhood, and what type of chemicals are they emitting, so that you can be informed. So you're dealing with a much more informed public, where once they get notice that there's a project in their neighborhood, they can become participants in the process of approval, more so now than in the past.
Can I delve a little bit deeper into that? And the problem I see just off the bat is, how do ordinary citizens get noticed? I mean, is it those teeny tiny words and ads that are in the back of the one ads? Are the citizen advisory boards maybe set up before a project is proposed? How does somebody know something's coming to their neighborhood?
That's a really good question. And in Florida, we have a very advanced public notice system. For example, local governments in Florida that are approving brownfield redevelopment projects, they have statutory requirements to notify the public in a certain letter print in the newspaper of general circulation. They also have public hearing requirements at the state level that require the DEP to notify more now than a year ago people that live near the neighborhood. More now. We have new public notice requirements where the state, once they have a project that's going to have some contamination associated with it, they have to notify the public within a certain radius of the property in a certain type of magazine or newspaper, and they also have to notify the media, depending on what the project is. So in Florida, maybe more so than other states, we have very accelerated public notice requirements, both at the state and at the local level. And it's more than that cryptic signage that you might find in a newspaper business section. No, it has to be there's certain standards of what type of newspaper you have to publish in.
Okay, so it can't be the neighborhood newspaper that says I've got a car to sell and I've got pool supplies to sell. It has to be in a real newspaper of general circulation. Let me ask a little bit about how these arise in your practice. Now, having practiced environmental law for many, many years, and I was director of legislation for environmental, for EPA, state EPA here a few years back. How do these EJ cases actually interact with other environmental protection laws and programs? Like, for example, Army Corps of Engineers has regs, Department of Defense has rules, Department of Agriculture has rules, Department of Interior. States have their rules and regulations. Some cities do. How do environmental justice issues interact with these other laws that are on the books intended to provide environmental protection?
That's a really good question, and I think the very first thing you have to think about it is at three levels. There's the local, there's the state level, and then there's the federal level. At the local level, we've talked about already how environmental justice issues arise in public hearings. At the state level, when a permit is going to be issued, which is similar to the federal level, there's usually a notice of issuance of permit. If you remember, back when you were lobbying a lot, and and organizations such as the Legal Environmental Assistance Foundation, you remember them? They would pay attention. Yeah. They would pay attention to those type of notices, a notice that a permit is about to be issued, and in that process, there's an opportunity under the Administrative Procedures Act, and we have one at the state level and one at the federal level. And when this agency decides that they're going to issue a permit, and they issue a final agency permit, and there's objections, and there's an environmental justice concern or any other concern where a person that lives within a certain radius of the project can prove that they have an interest in, that creates a point of entry under the APA to be heard in Florida with an administrative judge. And at the federal level, it similarly has a point of entry to be heard within the district court. And what you find is that organizations such as the NAACP, the Legal Environmental Assistance Foundation, Audubon Society, the environmental groups sometimes take on the cause of the community, and they file a petition on behalf of interested people, and in that context, within an administrative judicial context, you have some review. So, for example, you mentioned the U.S. Army Corps of Engineers. Okay, so
yes.
That's an agency at the federal level that issues permits and authorizations, and that means that their final agency action is subject to Administrative Procedures Act, and so it's subject to review. So, for example, in this recent groundbreaking Standing Rock case against the U.S. Army Corps of Engineers, the reason that case was so important is because if you're new to environmental justice and you're trying to understand what it means, the first thing you're going to ask is what you ask: what's the law? Well, there is no law. There's no environmental justice law. There is an executive order issued by President Clinton in 1994. If you read that executive order, it specifically says it does not create any judicial right to review a permit or any agency action. It creates a work group. And then there's guidance documents. EPA has many guidance documents, and what the guidance
that creates a right to be heard, but not necessarily in a court of law.
Exactly. It just directs the agency to make it a priority to evaluate how their decisions are affecting low income and poor communities. And it's a charge for them to organize themselves and interpret and look at their existing rules and see how they're implementing them. But the reason the Standing Rock case, Nikki, is so important is because it takes a guidance document, an executive order, and interprets it in such a way that they subject the decision of the Army Corps of Engineers to the APA's arbitrary and capricious standard. And they create a point of entry for the court to decide, well, the environmental justice analysis done by the Army Corps of Engineers is arbitrary and capricious, and for that reason that project is not approved.
Now, let me ask you about the Standing Rock case. That was the case where the Standing Rock Sioux Tribe and the Cheyenne River Sioux Tribe won a very important case in June. I looked at the decision. It's a 91-page decision. That's a heavy-duty decision.
It really is.
Is there anything in that decision that has any kind of long-standing significance on EJ issues?
I think so. First, it depends how it's going to be interpreted by other district courts, but certainly it's going to be a groundbreaking opportunity to review federal action, core action. Federal agency action, I think you get beyond the core action. Where in this particular decision, there were two pieces of that the court relied upon. They relied on President Clinton's executive order. Okay, that order applies to all federal agencies. And then it relied on the Environmental Justice Guidance document for the National Environmental Policy Act, which reviews agency action. So both of those pieces can be used again and applied to other agency actions beyond the Corps of Engineers, any federal agency action. And what it does is it says that if a federal agency voluntarily, in their discretion, evaluates environmental justice issues, then it's subject to an arbitrary and capricious standard. And so what the Corps did is they evaluated environmental justice issues in their decision and concluded that there was no environmental justice impact with a very short, like 2 or 3 sentence conclusion. And the circuit court said, the district court of D.C. said, that was not enough of an analysis. And it gave maybe a 3-page description of what they consider to be a thorough environmental justice analysis. And it's great. I mean, it says that you're supposed to contemplate impact on low-income and minority communities, indigenous communities, in this case the Sioux tribe and other tribes, and you're also supposed to consider unique cultural impacts that affecting this lake in particular, Lake Coteau, would have on that particular community. This is a community that fishes from the lake and has other. Yeah, they have other and has certain specific rights to that water. Exactly. So this is groundbreaking because it says to an agency, if you're going to evaluate environmental justice in your analysis and in your decision making, then you will be subject to an arbitrary and capricious standard. And so that opens a whole body of law. Now, who gets to raise that issue? I mean, is it the plaintiffs or petitioners who get to raise it? Is it the Corps of Engineers that gets to bring it up in their defense? Can other parties intervene? Can a party say, for example, intervene with a pleading that says, for example, this is how the project will affect the Sioux tribe. This is how the project will affect the Cheyenne River tribe. But this is how it will affect my community. So can a group of people intervene and bring up additional issues? Absolutely. I think once the NEPA decision is written and it contained environmental justice issues or even touched on the fact that there was no environmental justice impact, it raises an opportunity for any affected party to critique that decision and say, you overlooked our community. You drew the circle around the project too small. We're located outside of we're located outside of the geographical limitation that you made. And so that's what I think you see. You see briefs from amicus curiae briefs from tribal community organizations that are critiquing the environmental justice analysis, and then you see a court that agrees with them. So then there really is more than one point of entry for concerned citizens to get involved. Yes, absolutely. I think once there's final agency action, it's subject and it's subject to review by a court. It opens the point of entry for the public in general. And now, which entity does the fact finding in a situation like that? Will that go to an APA judge, an administrative law judge? Yes, it goes to your to make findings of fact. Yes, absolutely. And then what is the court to review? I think that the court is reviewing the APA's record, just like we do in Florida. You review the APA's record, and you make a decision based on your review of the record and whether or not there is substantial evidence to support the decision of the agency. And if not, if you feel there's not, then the finding is arbitrary and capricious, and you go back to the drawing board if you're the agency. It pretty much stops the project. This is really interesting. Now, let me ask you about funding. Of course, we're all aware that the current administration has talked about and has probably begun to defund some of these programs. The Trump administration has begun to defund positions and sometimes whole programs. How do those funding cuts affect environmental justice issues, and how can we expect that they will over the years? Well, I think that that's a really interesting question. I've seen a budget that proposes to defund environmental justice program, but the environmental justice program, I think it's been pretty dormant anyway. What I have seen in the past, and we've seen it in Florida, is that environmental justice issues tend to lean on the interpretation of existing laws in such a way that it encompasses impacting everyone, including poor people and people of color. And so you have so there's a political component to the interpretation. So in those administrations where you have a lack of encouragement to interpret environmental justice issues, what you see then, I think, is people going to the courts for justice, going to the hearings at the local level. And what you find, I think, is, and I advise my clients about this all the time, you find more organizations such as the NAACP and the environmental willing to sue a business. And there's a downside to that for the business.
Sure there is. It's got to be more expensive and more time consuming.
Absolutely. It's more expensive, it's more time consuming, but for members of the boards of these businesses, there's one thing I think that's even more important than that, and it's the brand of the company being affected by the public coverage of the litigation. It's just
Tell me what you mean by that.
Well, what I find is with my clients is that and I represent Fortune 500 companies, they take great pride in being good business citizens. And none of my clients want their brand standing under the sign of environmental racist.
So then you and your clients will take a proactive role in working with communities.
Absolutely. And at the board level and at the advisory level with the general counsel on the board, the first recommendation is to recognize where your facilities are located and who your neighbors are. And the reason for that, again, is because the people on the boards for the clients that I represent, they want to be good corporate citizens, and they don't want their brand dragged through environmental racist articles in the newspaper, and they want to do the right thing. So
that's interesting.
Yeah, so with my clients, I have always taken a very proactive approach of evaluating where the property is located, what are the neighboring uses, and who are your neighbors.
That's really interesting, Maribel. So over the years then, have you seen differences in how cities and other governmental entities approach their placement of things like sewage treatment plants, landfill, other siting cases, pipelines, oil drilling sites? Have you seen that there has been an improvement over the years in the communication between corporations and citizens and communities?
Yeah, it really, I'll tell you, the history of the facilities is really important. And what I mean by that is that you have some locations, like in South Florida, where the landfill was sited first, maybe 40 years ago, and the neighborhoods came afterwards because people started selling
because it's growth,
cheap real estate. Yes. So the people migrated to the regulated facility. So when the landfill was originally sited, Nikki, they were out in the middle of nowhere, and now they're like in the middle of downtown or within. They sure were.
Years ago, you could ride by Mount Trashmore in Lauderdale, and there wouldn't be anything near it. Now there's neighborhoods near it.
Now there's neighborhoods near it. So now what you're seeing is the facilities that are finding themselves to be hosts to neighborhoods, universities nearby have to take a proactive approach in educating people what they're doing at their facility. There's an emphasis on public education, providing information, because the very first step of any relationship, including a regulated facility with their community, is trust. So you have to tell them what you're doing, what your operations is. I have clients that I have them invite people to take tours through their facility to see what it is that they're doing. Educate people on, and it starts at school. We have kids coming through the facility, seeing what happens to water when it starts in your sink and it comes out on the other end.
Very good.
And we do the same thing with the landfill. Show them how separating the different types of garbage, how that ends up with having recycled garbage versus non-recycled and where the non-recycled go. And it's such an education so when you find facilities that are already there, then the key is to educate people. Now, when you're trying to cite a new facility, that you have the opportunity to examine and do your due diligence about the existing land uses and make a decision, a personal, I'd say personal in quotes, but a corporate decision internally whether or not you want to contribute to that neighborhood with your regulated facility or not. So I think that because environmental justice is an issue that has grown over the years in Florida to the point it becomes a business issue, just like any other potential environmental liability, you evaluate environmental justice on the front end. You do it on the front end. You don't do it after the fact on new sites.
It's really encouraging. Yeah. Now, it used to be, especially in urban areas, it used to be that these unwelcome facilities, things like landfills and things like incinerators and things like that, used to be that those would be lumped together in one or two neighborhoods. Is that still happening?
Well,
because what would happen is that the companies would buy the cheapest land, and the people who lived by the cheapest land would end up with sewage treatment facilities in their neighborhood, a landfill in their neighborhood, all kinds of undesirable projects just lumped together.
Yeah, I think that's when environmental justice really came to the surface in Florida, and that was in 1994. And in 1994, it came into the surface following the executive order that President Clinton issued. And Florida said, let's take a look at our neighborhoods. Let's see if that's really happening in Florida. And what they did is they created the Environmental Justice Study Commission in 1994. And the job of the commission was to answer that particular question. Were there clusters of undesirable regulated facilities being in certain neighborhoods, in poor neighborhoods, urban neighborhoods? And we held hearings throughout the state. I served on that study commission. I remember going down to the Everglades and the hearing in the Everglades because of the facilities related to sugar industry there. And I remember in Fort Lauderdale we met because of the municipal landfills, and there seemed to be clusters of landfill activities and other undesirable regulated facilities. And the conclusion I remember the study commission reached was that there wasn't an intentional act to cluster these facilities in certain neighborhoods, but there was, in fact, like you said, real estate-driven reasons why cheap property was available, and they're there, and neighborhoods kind of migrated to them because the residential property was also cheap. And so the question was, then the next question was, how do you hold those? Are we holding those facilities to the same cleanup standards and enforcing the environmental regulations the same irrespective of the makeup of the community, irrespective of
that's exactly the question, because so many times, especially in older cities, it's poor people who live around the corner from a sewage facility, a sewage treatment facility, or a landfill. It's oftentimes the voiceless. There are people who feel disenfranchised, who feel like they don't have a voice. So it's sounding like with this corporate responsibility, you're actually searching for people to be able to talk about how the projects will impact them.
Yeah, absolutely. And I'll tell you what, we take it one step further with our brownfield redevelopment projects. When I advise clients that find a gas station, for example, in Miami, that they want to redevelop, I ask them to participate in the local Citizen Advisory Board, and it's usually the downtown area that's already designated for development. It's an enterprise zone, or it's some kind of economic redevelopment target area for the local government. And if the local government is advanced, like Broward County and Miami, and they have a brownfield redevelopment program, you can go through the program and ask the community, Nikki, what do you want? What do you need? A pharmacy, a gas station, and you actually try to incorporate the vision of the community, your future customers, into your development plan.
It sounds fascinating. Can you talk about briefly what a brownfield redevelopment is?
Absolutely. A brownfield redevelopment project is pretty much when you try to make something out of nothing. You have an abandoned gas station, for example. It's sitting idle. It's no longer underused. There's some underground storage tanks.
Right.
It has uncontrolled contamination. It hasn't been looked
So it's already
it's just sitting there. It's
intense water quality issues.
And so then you have a developer that says, this is on an intersection, Maribel, and I really think that I can build a Walgreens here. So then the question is, okay, we can have it designated as a brownfield site, and one of the recommendations of the Environmental Study Commission in Florida was to try to address these contaminated sites by creating some kind of program that would allow you to redevelop them. And so the Brownfields program, I think, is one of the results of the study commission. And we have a very advanced Brownfields redevelopment program in Florida where you designate a property that's contaminated as a brownfield, and there's a designation process at the local level, and the Citizen Advisory Committee looks at the property along with the developer and proposes a development. And if you propose a development, for example, like a pharmacy, and most of it is going to contain a building and a parking area. Under the Florida Brownfields redevelopment program, that property could have a cleanup plan that is based on its end use. So if you remove all the tanks, for example, so the source of contamination is removed, and you cap the area of contaminated soil that is not migrating, you cap it with the parking lot, you've created an institutional control that will eliminate exposure of the community to that soil now by the concrete cap. And then you use that as your parking lot, and you put your building on the property. So under the Brownfields redevelopment program, you can negotiate cleanup standards based on the use of the property.
Okay, so it's not necessarily that every brownfield redevelopment project can put a parking lot cap. Sometimes, I imagine, those areas have to be cleaned up so they won't become a hazardous waste site.
Exactly. Sometimes you have to remove contaminated soil, fill it with some clean soil, and then cap it, depending upon the amount of contamination that's there. It also depends if contamination is migrating off-site or if it's contained on-site, the type that doesn't move. And it also depends if the people are on city water as opposed to water wells.
Oh, sure it would.
Yeah. So all of these are factors that can be considered, and the goal would be to take this property that's uncontrolled contamination and convert it, or pretty much recycle it to a optimum use that's serving the community and that's cleaned up.
Are there any kinds of issues that are unique to Florida, any of these kinds of issues?
I think water.
And Florida has so many different kinds of geography within our state, and we've got so many different kinds of populations within our state. What do you find that's unique to Florida that other states and the feds may not have any interest in?
Well, I think our water quality and water quantity issues are becoming more and more dire to Florida because we have such a growing population, especially in South Florida. And if you have to think about the state geographically, you think about like Orlando down is very sandy, very shallow groundwater table. Orlando up, closer you get to Tallahassee, it's more like southern Georgia where you have the clay and lots of hills. So so that's unique to Florida. And arsenic is a naturally occurring constituent that you'll find a lot in Florida, which is unique to Florida. Absolutely. Its background levels exceed some of the cleanup target levels in other states. And so there's a lot, there's the uniqueness of our shallow water table, our sandy soils, the further south you go, make water quality a major issue in Florida. I think that's why we have always been a leader when it comes to environmental policy and regulation. We were among the leaders on environmental justice. We were certainly among the leaders on the Florida Brownfields Redevelopment Act and on Everglades cleanup. I mean, water quality has been a nonpartisan issue in Florida, which I love.
For years and years, yes.
Hasn't it, Nikki? I mean,
for decades.
It's nonpartisan. Everybody wants it. Everybody needs it on different levels. If you want to look at it from a community standpoint, you have party that says definitely water quality issues is a priority. And if you want to look at it from a business perspective and you own resorts and you want tourists, you're going to say water quality is a number one issue in Florida. So that makes us, I think, on the forefront. And we being the regulated community, we've always worked in a team approach with impacted communities and universities in Florida to address water quality issues, cleanup issues, environmental issues.
Now, it's not always that smooth. My recollections are, you've got all these stakeholders, you've got all these groups who need to work together, and you've got a citizen group who wants to make sure that they have good, clean drinking water. You may have the cattle industry who wants to have good, clean drinking water, but they have additional issues that they're concerned with, which may lessen the quality of the drinking water, but may make it fine for the cattle.
Right. You're absolutely right. And that's because we have so many industries in Florida. We have, chemical manufacturing industry. We have the sugar industry, the cattle industry,
right,
the orange orchid industry.
That's right.
So but all of them rely on some clean water or some abbreviated type
right.
of quality water. So that's the common denominator. I served, Nikki, as vice chair of the Florida Environmental Regulation Commission, which is the rulemaking arm of FDEP. I had to find ways to build consensus with very polarized groups sometimes. But the common denominator every time, and every issue that I remember facing, and Everglades cleanup was one of my issues, was that everybody agreed that we needed water quality, a certain amount of water quality. It was just a minimum requirement in Florida, and that made people come to the middle. You always had those polarized, people out on the right and on the left, but at the end
right.
of the day, the majority would somehow get in the middle because we created a soils forum to address, to have a forum where people with different stakeholders can discuss cleanup target levels for soil, and the state of Florida was among the leaders of coming up with soil cleanup target levels, which became our Brownfields redevelopment program. So I'm very optimistic about environmental justice.
It sounds like it.
Yeah, it's never went away. It's everything they're doing at the federal level. We've done it here. It's tend to be pushed down to the local level, and it's heard at the local level, and it's resolved at the local level, just like you would resolve any type of issue that you would want in your backyard. Yeah, that's how it's resolved.
This is fascinating. Now, when you get all these groups together, if you had a project that was going to affect communities where people live, it was going to affect the cattle industry, going to affect the citrus industry, various industries, do you work through a formal mediation process to try to get people to consensus?
I have seen if it's a project, you usually use the local government's citizen advisory board, city attorney. That's how you resolve it at the local level. At the legislative level, it has always been an informal work group scenario where people come together around and volunteer to work with a member, for example, that sponsored legislation to come up with a compromise. Now, if it's a rule, like if it's a rule that has been adopted and there's controversy, then that's when you see the mediations. You see someone challenging the rule, and then now we're in an APA kind of format, and you can decide
right.
go to the hearing officer or you want to try to mediate it. So when there's a rule, even if it's an emergency rule and it's temporary, that's where you see the regulated community come out and start following the APA process, and that could lead to mediation.
Maribel, this has been absolutely fascinating. Thank you so much.
Thank you.
To the listeners, this is great fun. To the listeners, thank you so much for joining us today. And again, our program has been sponsored by the ABA section on environment, energy, and resources. You can find out more about the section, including how to join, at our website, www.americanbar.org/environ, ENVIRON. Until next time, this has been Nikki Ann Clark, and thank you so much for listening.